you don't go to a dispute about, say, family law or any legal dispute without knowing your legal rights, okay? You should know your legal rights, your obligations, the likely outcome. But after you know all that, be also prepared to be as flexible as possible, because what at mediation you can do could be much wider. The possibilities are much wider than maybe what a judge can do.
Okay, life can be crazy. You're feeling like you're sinking, just trying to find a meaning. It's time for better thinking, yeah, better thinking. Time to tune in. Let's go.
This episode of Better Thinking podcast, I have Carlos Turini, who's a family lawyer and also the chair of this Alternative Dispute Resolution Committee of the ACT. He's obviously an accredited mediator himself also. What he provides today is his experience and insight in being a mediator, how to go out and prepare, how to go and engage in mediation, and also what you might be able to do to get the best result. I think you'll find this really, really useful. I know that last time I had Carlos on the show, I had lots of great feedback, so you'll enjoy this one as well. Welcome back to the podcast, Carlos. It's fantastic to have you back talking about mediation and how we can prepare for it, particularly in, obviously, family law, your expertise. I know that you and I spoke about this over pizza not long ago and thought this is a great topic, comes up all the time. I know that I've got clients that are going through these challenging times and, hence got you back on and excited to talk about preparation. What can we do? What are the pitfalls? Why is it such a hard process? Most of us don't have a clue what we're getting into.
No, thank you, and thank you for having me. Yes, that was an interesting conversation that we had, and I think it was good because we both came from different directions about the same issue. How do you prepare for a mediation from a point of view of the legal preparation or the preparation of facts and so on, but also how to prepare yourself psychologically. So that was a very fruitful conversation, I think, that we had. So we can continue it today. I think it's important to explain what mediation is. Perhaps one definition that probably is the most useful one is an assisted form of negotiation, which means basically two parties negotiating with a referee, if you like, to set the rules. And it's very handy because it allows people to speak without interruptions, and it allows the other party to listen. And then, and the rules are don't interrupt the other person until they had their say.
That's probably one of the bigger sort of points that mediation provides by virtue of having a mediator, is that people are probably more likely to behave, in a socially reasonable way with there being a third party in the room. The fact that they don't talk over the top of each other as much. Yeah. I'm sure there's probably cases that you've seen where it hasn't necessarily been the case, but there will be a mediator there, meaning a third party present to assist, and most people will behave a little bit better.
Exactly. It assists to allow people to behave. There has to be a degree of civility about it. You cannot allow it to turn into a brawl, the discussion. But there's nothing wrong. I personally don't think there's anything wrong with some emotion. You will get some emotion. And I think sometimes you hear people involved, sometimes lawyers are involved in the process saying, let's try to not get emotional. Well, I think it's okay to get emotional, provided...
It's a crazy idea that someone doesn't get emotional. Yeah. I mean, the reason why they're there is because they're talking about something that hurts, that's close to their heart, that's upsetting, and, they've got very, very different opinions on the matter.
Exactly.
It's naturally going to create, at least, I'd have to assume, either frustration or anger or hurt. upset. Why else are we there? We're talking about something important. I'm going to fight for it.
I think it's healthy to allow it to happen if it happens. That people get somewhat emotional, and sometimes you may have to have a break. The best way to organize a mediation is to have one room where people meet face to face. That the best mediations, I think, are face to face rather than there's alternatives. They're called shuttle mediations, where parties are in different rooms and the mediator goes from room to room. And but allow people to have breaks, to go when things get too emotional, so that people have the capacity to have a break and then come back.
Yeah. I think the shuttle version, because I've been in both for differing matters, not family law. I hope I don't have to go down that one. But I found the shuttle one was excuse my language, but bloody awful. It was shit.
Yeah.
The reason why is because we never got any traction. Yeah. You by the time you go out and propose a position to the other party, and then the mediator walks out of the room, goes into another room. They spend 15 minutes chatting with the other party to come back with something, and then you hear about it, and then you kind of sit there and come back with a position, and then it goes back again. It's like we could have had that conversation, so long as people were still reasonable.
In the one room.
In the one room, and probably in about 3 minutes, at least 3 minutes of back and forward, and obviously more in describing our positions. So I'm with you 100%. I think face to face. How else? How else can you do it? Now, obviously, that's not always going to be the case. If there's violence or something like that.
Exactly. If there's cases, I had one yesterday where it had to be shuttled, but I was well aware that my client spent 3 hours in a room on her own. Well, she had actually a companion, but I wasn't there. I was in a third room, and the other party was in the other room.
Can I ask why? Obviously, confidentiality in place and the rest of it. Why in that type of case did it have to be a shuttle? What was it that
because of the domestic violence? There is an existing domestic violence order, but I think shuttle mediation or by telephone, even by video link, are inferior. They are not as good as face to face in the one room. There's nothing better than the one room. I actually apply. I am a mediator myself, so I apply it myself to, for example, that each party start with an opening statement. So you invite people to make an opening statement about whatever they want to say, about what they want to achieve out of the agreement, whatever else they want to say, and have the opportunity to say it. And
it's fairly open-ended. It's kind of like, these are my feelings. This is what I want to achieve. This is what I'm pissed off about.
Yeah.
Why is it taking this long? Whatever it is, just they get an opportunity to put it on the table.
I'm very angry with you because whatever it is that they want to say, and then the other party has an opportunity to have their own opening statement, and perhaps they can reply to each other, and then the whole process starts. It continues.
Yeah. Right? Is that important that there is an opening statement and that both parties get to, air their grievances or put a position down or put their intent in place? Is that something that you specifically do for a reason?
I think it's useful to allow people to have their say. I think it allows people to move on to the issues, the specific issues, and then to address them. It allows people to start talking to an agenda and addressing the agenda. And I think an agenda is very important. So yes, I think for many reasons it's important to do it.
Is there usually an agenda? Like, is it usually a decent outline?
I think there should be an agenda. I think I think each party should prepare. I think that an agenda is part of what I call the preparing strategically and tactically mediation should not be about just turning up. There should be a lot of preparation before. There should be a lot of exchange of information before. The exchange of the information should not happen at the mediation. It should happen before. But in addition to that, to prepare, what do you want out of the meeting?
And
Points number 1, 2, 3, 4, 5. Yeah.
I'll tell you what, going back in my sort of experience of mediation, that was the thing that absolutely just pissed me off. I went in with, what I believed preparation around my position, what I'm hoping to achieve, which is in actual fact just resolution, to resolve something,
exactly.
to end this dispute, so to speak.
Yes.
And the other party, clearly came with nothing. And
No.
it was like, I thought the intent of, mediation was to come out with a result, or at least come closer to coming out with the result. And hence why, I think having a plan and a strategy is important.
If you're not, there's a danger that you're wasting your time.
Yeah,
And
it's costly.
Yeah, a good mediator will meet with the parties before and invite them to prepare an opening statement and to think about an agenda and actually and have a short conversation about what is it all about.
Where were you, Carlos, when I needed you?
There you go. I'm here now if you need me.
I'm happy it's out of the way. It's out of the way.
Oh, good. But I think mediation, negotiations is a great way. It's potentially the better way to resolve a dispute. It is. I always say you're limited by your own imagination about what you can get out of any form of dispute. Allow yourself to think, from anything that comes from left field. Allow yourself to think, be imaginative. Yes, you have to know the issues. I mean, I think you don't go to a dispute about, say, family law or any legal dispute without knowing your legal rights, okay? You should know your legal rights, your obligations, the likely outcome. But after you know all that, be also prepared to be as flexible as possible, because what at mediation you can do could be much wider. The possibilities are much wider than maybe what a judge can do. Right?
Yeah, absolutely. It kind of brings thought to mind around, I was selling my car recently, and I remember several times getting these text messages about, would you swap your car for my car?
All right.
Now, I was selling my car. I wasn't looking for a swap, right? Yeah. But at the same time, here's someone negotiating with me, right? Their position is they want to do a swap.
Yeah.
And I found myself... Yeah, absolutely.
You swapped a car.
I found, no. But I found myself kind of going, maybe I could think about this, even though my intent at the start was completely I know exactly what I'm going to go out and buy after I sell my car, et cetera, et cetera. But I found myself thinking about it. So I love the idea of saying, there's nothing that's off the table. You can be as imaginative, because you just don't know. It might be palatable to the other person.
Exactly. And you do need the framework. You do need to know what is likely or possible that may happen if a matter goes to court. Being aware that all the pitfalls of going to court, the cost, you may lose, you may not get what you want. People don't, litigation leads people to take positions and leads people to move apart. Mediation tends to break barriers. I have found one of the most surprising things after mediation, even with all the emotion, even people at times shouting at each other, that when the mediation finished, there is an outcome, and you see people embracing and crying, and you think, it is quite special. It is quite special. So it is a good way to resolve matters. Yeah.
I imagine there's a hell of a lot of relief. It's kind of like we don't have to yell at each other anymore. I don't have to go out and, feel my heart race and churning in my stomach when I see an email from you.
Yeah,
I don't have to kind of worry each time I I pull letters out of my letterbox and worry that it's another one from the lawyers, or the matter just kind of weighs on your shoulders, and it's awful.
Yeah, exactly.
There's
I
relief.
think I agree that largely that kind of reaction is relief that the problem is gone. But also these are people who at some stage had a relationship and were very close. So suddenly, it takes away, when you take away all those positions and so on, what is left? I'm not a psychologist. You tell me.
But I can imagine. I can imagine there being also, at least potential for a reflection point in someone of saying, "Wow, we can do this."
Yeah,
kind of like this is what was lacking in our relationship. Is a means to get to an end, and we've just done it.
I was just watching SBS last night. Do you watch Insights about these couples that got together again? Maybe there was one couple 42 years later, and
they divorced and got back together.
Yeah, they go back together again. So is that what you're leading at? But no, it's true. I think it does help. Actually, from my point of view, sometimes mediations, by the way, can be lawyer assisted, so the lawyers can be there, or the lawyers are not there. Sometimes negotiations are without lawyers, but that's different versions. But from a lawyer's point of view, when I hear the other person talking, I never look at the matter again the same way, because as much as the other side's position, maybe from letters or whatever, there's too many people in between with lawyers, I think. So it is very helpful to me too, to understand the dynamics of everything when you actually meet the other party and they put in their side of the story.
I think I could probably explain that, and that is witnessing the emotion.
Right.
That when you're in the room and you witness one's emotion, you witness the language that they use, not the lawyer's language, but the person's language.
That's right. Yeah.
When you observe their pauses or their hurt or their anger, that you can see there's more to the story, that they might talk about a history that you're not aware of. The fact that you get to kind of meet the humans, not what they present to you, but how they've been with each other.
That's right.
Would I imagine in some sense, be completely enlightening about, my goodness, I haven't seen this side of the case.
I mean, you could
not always.
You could argue. I mean, maybe this is a reason some people may argue for not having mediation. But what I'm going to say, but I don't. I have heard that argument before, which is this. Sorry, you don't do mediation with the other lawyer watching you, because the other lawyer is assessing you as a witness, right?
Okay.
So I get it, but judges are very clever to work out people's character and what people are like. You don't fool judges anyway. So just I don't know that is an advantage necessarily, unless you are pretty bad at speaking.
Sure.
I don't know. And then the other lawyer can make an assessment. You're going to be a rubbish witness. But even then, I think judges at the end of the day work out the true character of people. Yeah,
I think the judges are going to be pretty damn sharp. They're doing this all day, every day, and they've seen when people are pulling the wool over each other's eyes, and lying, and then it's you can clearly see it's not credible in the evidence, and so on and so forth. You'd have to be doing a pretty damn poor job on the other end not to expose that as well.
That's right. There's a lot in the preparation that you have to do too. I mean, that's what I always say to people about mediation. Think about, and you're asking about the agenda. Think about what you want to get out of these. But not only that, think about what the other side wants to get. And how can you get what you want in a package where the other side is getting some of what they want, perhaps, So don't just think about yourself, think about the other side. And you were talking about outcome. It's about an outcome at the end of the day.
It almost feels also that when one steps into mediation, the resolution point is likely to be both parties feeling equally unsatisfied.
there is some of that.
Neither will likely come out saying
with everything
that was an exceptional result and I'm so happy with. It's kind of like I've had to concede. Yeah. There's something I've got to give up, and something I gain, and how can we tease this out, even if the thing that we want to gain both is the same. Yeah. Maybe there's something that.
That's right. No, usually that's what they tell you, that probably a good outcome is one where everybody's a little bit unhappy, but you found the solution somewhere in the middle.
Happily dissatisfied.
Yeah.
Right. I mean, it's a great result.
Yeah, and I think, outcomes are subjective, not and that was hard for me. I mean, I train as a mediator, but I've been a lawyer for 3 decades, and it's a different discipline altogether. It's quite a different discipline, and that was one of the hardest things for me to understand. I guess maybe I'm thick, but it took me a while to understand that it's not about the outcome; it's about their outcome. It's not about the truth; it's their truth.
Yes.
You understand? You understand what I mean by that? What is important to a person. And I remember doing an example, like a mock mediation when I was training, and it was somebody just got some dry cleaning, and they had a stain on it or something, and what was it that the person was after? And all the person was after was an apology, and eventually it came out. And you're thinking about the dollars and how much to replace. You're thinking of all these things, and I will tend to cross-examine the people about what the truth is, and it wasn't about the truth. It was about what they were after, right? And that applies to every mediation. So I think the key for a mediator is to try to find what it is. One example, maybe I can give you one other example if you don't mind.
Absolutely.
This was many, many years ago. It was a client, I without giving away too much, but it was a client, an old migrant couple who were financially very well off. They worked really hard to make the money. The children had, some of the children had addictions and problems like that. I was acting for the wife, and someone else was acting for the husband, and there were barristers in between. I was quite proud of the outcome because I worked out what the problem was. And the problem was that why we couldn't settle it, and we did settle it, was that the husband in that matter was worried about his elderly wife getting the assets and then eventually going to the children, when what he wanted to do was to avoid one generation and give it to the grandchildren, because he didn't think he could trust these children who had addictions, gambling, and all kinds of other things. So I suggested, well, why don't we create a trust to give it to the grandchildren? And that solved it. It solved it in
Instantly.
2 hours.
Wow.
It was done. And it only occurred to me, so I'm proud because I came up with the idea, not the barristers. And
it sounds like so you were representing her?
Yes.
Oh, yeah.
Yeah.
So
the idea was she got what she wanted,
yes,
but there was also a trust for her share to eventually go to grandchildren, like he did too. He did the same
thing. Sounds like that she wanted that too.
That's right. They was happy with that. They were both happy, but it had not been communicated, right? Because they hadn't spoken for a long time. But so that's not about the truth. It's not about the truth or reality. It's their reality. That's what they both wanted to achieve out of that. So yeah, it is important to. One of the things that they tell you about mediation is
we might turn you into a psychologist at some point. Sorry, you were saying.
Listen. Yeah. Always listen. Try to listen to what not just the lawyer is saying, but the other lawyer, but what the other party is saying, as well as your own client, of course. But it's very important to understand where they're coming from. And the answer is not necessarily legal. It's not a legal issue. As I said, the apology, that's not a legal outcome, is it? It could be anything else.
I mean, as you say, that trying to figure out what the parties want, often we need, as human beings, a story to tell ourselves.
Yeah, that's right.
You know, I think we've all probably gone out and, I don't know, let's say purchased something and then found out that, you know, the next week it was $50 cheaper. But we have to give ourselves some sort of story to reconcile it.
That's right.
So we go and say, yeah, but I really needed it and I used it on the weekend. And if I went to go and hire it, I would have spent more than $50.
Exactly,
you know?
yeah.
We just come up with some sort of crap to go out and a full story to reconcile it.
We can justify anything in our heads, can we?
And that might be the justification of they apologised. They were wrong and they acknowledged it.
Exactly.
And that's what I needed. I don't care about my, you know, suit or whatever it was that was damaged.
Yeah, that was done. It was done. You couldn't fix that. But that person didn't even want a replacement, supposedly, only wanted an apology. So it's important always to listen, and there's a lot of preparation, but also to do a lot of listening during the negotiations, during the meeting. Yes.
So it's really important to, I suppose, be clear, to do the preparation about being clear. I mean, what it is that you want.
Yeah.
Maybe take the position of the other party to look at what do you think they might want.
Exactly.
But play with a few perspectives there, because you're running assumptions. You think you know what they want, but you've got to kind of examine that a bit more.
That's a good way of putting it, to think beyond. Don't just allow your assumptions to take over, or your mindset, or whatever, what your conclusions that you reached about the matter. And sometimes you come out with amazing. I can't remember if I mentioned this to you before. Maybe I did. The type of when I say you're only limited by your own imagination. Imagine this case where you got husband and wife who split up. They have a house. If the matter goes to court, the court will make one buy the other party out, or you have to sell it. But the parties could agree that because the children are young, the children say will stay with mom or dad, and the house will not be sold for 10 years to allow the other party to recover. The court cannot do that. And it could be, well, if we do it now, 60-40 to you because you have the children. If we do it in 10 years, 50-50. Right?
Yeah.
So it is an outcome. It's an outcome everybody can live with, but it's something that a judge cannot do.
And it's something much deeper.
Yeah.
Because at that point, it actually taps into, you know, what are we fighting about? And if it's about the security for the kids, for example, or whatever it might be, that might be palatable. They could go out and say that actually works for both. You know, it's a win-win scenario.
Yeah. And but you have to remove, as a lawyer, you have to remove your lawyer mode when you walk into that, whether you are the mediator or assisting your client. So you have to wear both hats, if you like. Yeah.
And then I suppose, you know, talking about, I know that when we discussed this before, we're talking tactics as well. And I know that's probably not the right word, but in some sense it describes, you know, preparation and then how to try and position yourself for your outcome. I think actually we're talking about how I purchased my house.
That's right. That's right.
Actually, we might as well share it now as well. I was watching one of those shows where someone goes out and purchases, let's say, a crate of, or say a garage of a storage room, that is, of items, and they have to bid on, you know, how much they're willing to pay for, you know, the storage room of items that have obviously been abandoned or whatever it might be, and then later on they see what they can off-sell and so on. And I remember watching a guy who, his tactic, which resonated for me, was he's going to hold the highest bid all the time. He really wanted this particular storage room. And, you know, because he obviously felt that there were items in there that were of great value. And so the moment the bidding sort of started, he would go in and, you know, he'd say, okay, $200. And the minute someone else, you know, would bid $250, he'd go $3. So he'd jump immediately over the top, you know, and if someone then goes, $320, he goes $350. And I remember him actually kind of being a bit more louder, boisterous sort of thing, and just jumping on it.
Yeah.
And so I use that tactic. I had this kind of idea. My wife and I were looking for a house for like 10 months, maybe even longer. And I remember, I was nervous as hell, shaking, but you don't show that. Put on a suit,
Right.
a tie, came in early, parked my car, first car next to the driveway so that, I was pole position, registered early so I had number 1 on my card, stood at the front so no one could really kind of...
you were number 1 in every sense. Right?
And the moment the bidding started, because we knew the market at that point, I went to what would be a realistic number rather than, how it always starts slow.
Nobody makes a bid.
Absolutely.
Right?
The moment it opened up, I was in.
Right.
And so the auction started the moment that the auctioneer said, can I get a starting bid? Boom, there it is. Yeah. So I had it immediately. Yeah. And I did exactly what that gentleman on the TV show did. Every time a bid came in, I would just go, yep, just basically yell over the top. The person wouldn't even finish their number. And I would, have my card up in the air. And we got, all the way to basically the end, and a gentleman that was bidding, it was just left to me and him. The gentleman that was bidding, his wife was saying, come on, let's go out and maybe we can do just a little bit more, because they were getting close to their end, and so was I. I was willing to go a little bit further, but he said to her, "What's the point? He's only going to go over." Over us.
So okay.
That's brilliant. He believed that I was going to buy it no matter what, even though I had a ceiling. I had a number that I would not cross. Yeah. And I remember my wife was behind me so that she couldn't kind of whisper in my ear and persuade me a bit more. So I was solid, and at least in that occasion it worked. And so my tactic, my strategy was solid. It wasn't mine; it was from the show, but I executed it.
No, exactly. What you did was you had an agenda and you implemented your agenda. And I think if you want to control a meeting, you control the agenda, don't you? If you want to control a meeting, you control the agenda. I don't think, I always say that to people, if you control a meeting, if you control the agenda, you control the meeting. Don't assume you're going to control the whole agenda, but you're certainly going to influence it because you have thought about what you want to achieve out of it. You have thought about how you're going to package it, and you're going to do it on the day. In a way, you did something similar.
I ran a script, right?
You ran a script, exactly.
Yeah, I saw the script and I just played it out. And in some sense, if you have an agenda, you've therefore got a script of how you plan to negotiate that script.
Exactly. Yeah.
And there's probably flexibilities in that space, in your world.
Sure.
But you still have the agenda, and there's some flexibility, but you've already pre-thought a lot of your
I think it's important, The more preparation you do about that, the better. And don't just think about yourself and what you want out of it. Think about the other person. What does the other person want? And how can you, and think about the outcome. I want an outcome out of this, so maybe it's not the most perfect outcome to me, but what outcome can I live with? That's the other big question. What can I live with? What outcome can I live with out of this meeting? Right? It's important to think about that. Well, how far do I go? Which is your limit in your auction. You know how far you go.
And the truth was, how much am I willing to overpay for this?
Without losing control.
And I remember in my head how much more, what I thought it was worth, and how much I was willing to pay to secure it.
Right.
And what I was willing to pay was more than what it was worth in my head.
Right.
But that was the cost of securing it.
Yeah.
Thankfully, I didn't have to.
You got a good outcome out of it.
But I would have reconciled it anyway. I would have given myself the lie, right? Which is, I got it, but it's now gone up in value. If I kind of hung in there for longer, the prices would have gone up. I would have given myself some sort of garbage story to reconcile it.
It was good for my ego.
It was good for my ego. Yeah, I've got a story to tell.
I've seen actually auctions. Sorry, we're getting out of the subject, but they are so interesting, and they to watch the dynamics of what goes on in auctions. You see people losing control. I think I've witnessed people losing control just to win the argument. And that's crazy to do. It's a crazy thing to do. Yeah.
Well, I think that would happen in mediation all the time. If someone isn't prepared, right? So if they're not going out and doing the preparation and they don't know what they can live with, they lose control, become stubborn, and you can't mediate anymore because they basically cross their arms and say, it's my way or else.
Yeah. Well, we were talking about the opening statement before,
yes,
right? And in one matter where my client prepared the statement and she spoke for 10 minutes, she felt really good about it. The other side spoke for about 30 seconds, hadn't written anything, even though he was asked to, and it was suggested that he do it. And I don't think it. Well, I don't know if that's the reason why it didn't settle, but it certainly didn't help. I think what you said before about your experience with a mediation where the other party hadn't prepared, and they were asking questions about things that should have been clarified before the meeting. The meeting should not be about gathering information. All the information should already be on the table. It's not about checking bank accounts or whatever. All that should have been done before. It's about, okay, you have this position, I have this position, how do we meet? Right.
So it's almost like, and apologies for my naiveness, but it's almost like going to court early. There's just no judge to make a final ruling, but you're supposed to have, in some sense, your evidence put forward to go out and debate, so to speak, to kind of then use that as a means of what can I live with, rather than, there's confusion about the details, and so we can't mediate because there's still lots of conjecture around, how much the house is worth or something.
Yeah. It shouldn't be. I mean, I think all the information has to be on the table, so you don't waste time on things like bank accounts or whatever, But I don't think it's like litigation because you're still in control. In litigation, a third party, the judge or the arbitrator, arbitration is also an arbitrator making the decision for you. The third party is making the decision for you. In mediation, you're still in control about the outcome. So you own it to an extent, the outcome.
Yeah, okay.
Right? So you cannot say, oh, look what happened to me. Well, hold on. You decided this too together.
Yeah, that's vastly different. Yeah.
The one big thing that you have to aim at mediation is to ensure the level playing field. And you know what I mean by that. I mean that in every couple there is, well, maybe not every couple, but in many couples there is somebody who's more domineering, maybe somebody who talks more or whatever. The other person is a little bit more quiet, reserved, or whatever. I mean, the mediator is there to allow people to have a dialogue, to speak, and to force the other person to listen. All those things are important, but I think lawyers sometimes are helpful to create the level playing field. There has to be a level playing field. People should not settle at mediation because they are scared of the other party.
Does that happen a fair bit?
It is possible that it could happen. That's why you don't put them in the same room in a domestic violence matter, right?
Yeah, that's where.
Yeah. Besides any other potential danger.
Sure.
Yeah.
Or it could be simply that one person's not able to think on their feet.
Exactly.
In the presence of, the other party because there's so much has happened, they become overwhelmed. I mean, if I think about it from a psychological perspective,
that happens a lot.
Two people sitting on the other side of, a table facing each other, is going to bring arousal.
Some mediations, some matters are not appropriate matters for mediation. Some matters you have to decide, no, there's no way we can settle this matter. On the other hand, there are matters... What would an
example be?
Well, that type of case, say, where there is domestic violence or whatever, it's not a good idea to put them in the same room. Or if it was, a very serious crime or something that was committed, you don't put them in the same room. On the other hand, one of the things that people have said to me is that that's the first time that he was forced to listen to me without or vice versa. That's the first time she listened to what I had to say without interruptions, because the mediator said, you are not allowed to interrupt. You can write notes and then respond if you like, but don't interrupt while the other person is talking. So that seems to have a good therapeutic.
I was about to say, have you been listening in on my relationship counselling sessions?
Is that right? Okay.
Well, absolutely, because the same thing occurs where someone will often say, this is the most I've heard, about my spouse's feelings, or what they've been thinking about, for years.
Right. They have to listen, pay attention, and not interrupt.
Well, there's a professional in the room, in this case called a psychologist or a mediator, a lawyer, and, it's social etiquette to,
I scare myself sometimes having conversations with my wife where I answer and have a whole conversation.
You're scared of her? Or?
No, I'm scared of what I do, which is I have a whole conversation and I reply and I make sensible answers, and I'm not listening. How do you explain that?
You have to organise a few sessions. Does she know about this as well?
She does know that. So she tells me to listen, pay attention. Oh, okay, I better do that.
What would you say, and I know every case is so different, but what would you say is a good way to approach the actual active side of mediation? So here I am. I've got to this point. I've done some preparation. I've thought about, what I'm wanting to get out of it. Maybe what the other party's wanting to get out of it. What I can kind of live with. What I'm trying to optimize for myself, and so on. How can I best then engage in the process? And I know, as I say, it's not relevant for every case and every person, but what are some of the things that you found have facilitated and helped find that middle space where two people can, hopefully ultimately find a resolution in that particular meeting?
I do invite people to prepare. I suggest they should prepare well to do all those things about what they want, what the other side wants, what you think the other side wants, exchange all the information you have to, do everything you have to prepare. Prepare yourself psychologically too. You're going to spend maybe a day, maybe a full day, or it could go on for a full day. So prepare yourself, even energy-wise, prepare yourself for that meeting. But after you do all those things, put them aside and think, be prepared to be flexible. Be prepared to hear something that you haven't considered before, and that maybe instead of thinking, oh, this is out of the script, forget the script and think, maybe this is part of the beginning of a solution. So be flexible, I guess, to put it in one sentence. Be prepared to be quite flexible about what could be the outcome, right? So that's, I think, one of the major things that you should do. Because sometimes, as I said before, the most imaginative solutions come out of nowhere, or just from the meeting. Yeah.
So, in some sense, entertaining new ideas that might show up on the day.
Exactly. Yeah, that's right. And the rest is, well, obviously, be flexible. Also, as I said before, it's very important to think, what can I live with? forget about the fight. Yes, maybe you are in court already. Maybe you said a whole lot of things in court. That's another distinction between litigation and mediation. You can make concessions at mediation because it's all confidential. You could be having a mediation today, and the trial is tomorrow, right? So, in a way, you have to become a bit schizophrenic. In a way, you have to. You're running a different. You have a different attitude and approach altogether. So while you can make concessions during the mediation, you can then officially at the trial not make those concessions, right? So
in some sense, there's protection in mediation to go out and say, I'm willing to be flexible and open to scenario A.
Yeah.
And that then can't be used against you.
It cannot be used
court
against you. Exactly.
To go out and say, but you were willing to concede on that kind of.
If that came out, the judge will have to disqualify himself or herself, and the party whose lawyer made ask that question will have to pay the legal costs. So because you're not allowed to say anything of what happened at a mediation, except if there is an offer and an acceptance in writing, right? So if the outcome is this is the offer, this has been accepted, then that is admissible. It's not admissible. Yes. It's not. It doesn't mean that's the outcome, but the judge gets to know that was what was agreed at mediation. The judge may decide to do something else, but it is very. It's
harder
very,
for them
very
to go
tough.
out.
Isn't it? Yeah. But yeah, that's right. So you can. So that's quite an important distinction to litigation, that you don't have to be so guarded.
It opens up. I mean, that environment invites, in actual fact, to be flexible, to entertain ideas.
True.
Without there being any repercussions.
True.
Because, if we're going to ultimately end up in court, and this can't be, this won't be on the record, let's see whether we can actually resolve it. That's the true nature of the idea of mediation. Let's look at any alternative methods that's palatable to both. We can both live with it, and it can't be used against you.
Exactly. So that is very important. I mean, some people, if I can say as a general proposition with mediation, probably the word mediation is a little bit limited, because we're talking about one form of alternative dispute resolution. There are many other forms of alternative dispute resolution. Mediation is one of them. As I said originally, is a good definition is to say it's assisted negotiations, right? Somebody assisting for people to negotiate. Some people are very good at it and do it themselves. So alternative dispute resolution could go from mediation. By the way, there are many different forms of mediation. There is the one we have been talking about is what is called facilitative mediation, which is to allow people, facilitates people, draws the information out of them and draws them into negotiation. There are others, for example, the mediator could be a very authoritative person who is not a lawyer or is a mediator, but could be an engineer who's an expert on building disputes, right? And who is very useful because that's a very knowledgeable person. So it's it's more than just facilitating people to talk. It's to say, well, look, in my experience, the roof fell off because, of this structural problem or whatever. There is a thing called collaborative law, which is lawyers and parties and the lawyers contracting out of litigation. They sign a contract to say, we're not going to litigate this, we're going to negotiate it. And they do it without a mediator. So that's a form of negotiation, right? That's another form of alternative dispute resolution. And I always like to finish it off by saying it's also the husband and the wife, or the person who owes the money to the creditor, sitting down and having a cup of coffee and negotiating it themselves. So it's all ADR, right? It's all, but sometimes you do need someone to help you do it, but other times. And I think there is tactics and strategy for all those different forms of alternative dispute resolution.
What are some ideas about tactics? Obviously flexibility is one. The preparation side. Are there things that you've seen seem to be more useful in the process of trying to, I suppose, in some sense, sell that idea to the other party? Have there been some really great negotiators that you have gone out and seen who were able to kind of help the party they're in dispute with to open the door to these possibilities? Are there some people who do it much better?
Of course,
And what are the things that they do that if you kind of,
what they do, I think what they do is, the mediator should never be the role of the mediator, I think, especially in the facilitative model, which is the one that I prefer, to impose their opinions, right? It should not be that. But the very skilled mediators draw people to come up with their own conclusions in a very imaginative way, and probably helps them to get there. So that the parties own it, came out with ideas themselves, but they didn't realize how they did it. It was the mediator helping them to get there, right? Because it should never be you imposing your ideas, and in a very strict definition, you shouldn't be imposing even your suggestions. It has to come from them. Mm-hmm. It should come from them.
I think the first mediator I dealt with about that matter that I was talking about previously, it wasn't particularly crash hot, but the second one, much more mature gentleman, and I think he had experience of potentially being a former judge, or was incredibly sharp. And was able to allude to things we should consider, and without necessarily
imposing.
And that was very, very, very sort of considered in what language he would use around what might kind of stack up or not stack up, or whether something was relevant or irrelevant to the mediation itself, because it would kind of go onto some tangents. And I remember him, sort of jumping in with both parties, with both the other person and myself. And I thought he did an exceptional job. We didn't have an outcome at the end of it, but it felt like there was much greater clarity, and he brought us closer, which the
first mediator
wasn't able to.
So I think it's useful to have lawyers sometime involved in disputes, in legal disputes, obviously, to address. Sometimes people get stuck on certain points, and if you've got the lawyer saying, well, look, especially ideally unanimous, it's a unanimous opinion to say, well, the answer to this is such, well, you then move on, right?
And that's what I thought he did really well. He did not go out and kind of he implied, and he used lots of just reason and logic, I thought, but just in an elegant, kind of kind, gentle, compassionate way.
Yes.
So that it was impartial. He wasn't holding a side. And it felt like that because he'd pushed me as much as he'd pushed the other party. And I mean, I can't speak on the other party's behalf, but it felt like he'd cut through part of their logic in their dispute, and kind of in some sense squash some of mine to kind of say that's, you can't use that in some sense, not by saying that, but the impression was left there to kind of say, okay, well, if I can't use that, what else am I open to?
No, that's a good point.
And it was quite nice, I felt.
The example we were talking about of saying you're having the mediation today and the trial tomorrow, it is useful for you to know that strong mindset that you have is maybe there's two sides to that story. Maybe you get up or maybe you lose that argument. Have you thought about that? Because you may feel very strongly about it, but
it also puts incentive. It puts incentive in there, and that was probably one of my struggles as well in my matter, and not obviously going into detail, but it puts incentive for both parties to be aware that if you have to go to trial tomorrow, you're looking at $10,000 each for representation. And you may want to kind of consider that in making a decision today.
Yes.
Versus, doing the exact same thing tomorrow, and
you may not get an outcome for 3 months.
A worse outcome.
Or worse,
even.
yeah. It could be a worse outcome for you. You may lose the argument, or you get an outcome, and then there could be an appeal from that argument, so from that decision.
Yes.
So when instead you could partly own the outcome that day,
it creates space for what am I willing to live with.
Yeah.
Right. So the moment there's a greater cost, I think there's greater chance of mediation. Because it's like, but this is now reality.
Yeah.
Rather than principle.
Yeah. I don't know if you've been a witness. Have you ever been a witness in court? Have you have to be a witness in court?
I'll tell you a quick little story. I was called as a witness, and I was cross-examined by both parties outside the court, and then I wasn't used. But I was there all day, and I wasn't used. I don't know what that means.
Okay.
Whether I was not credible for either side or what it might have been, but both parties agreed.
Yeah. So how do you find the experience? Because I've been cross-examined, and it was terrifying.
Horrible.
Yeah, and I do it. I cross-examine other people, but when it happened to me, it was terrifying.
Yeah, it's ugly, right? The first thing they did, both of them, I had 2 rounds at it, so I felt excellent at the end of the day. The first thing they do is just absolutely destroy your credibility.
Yeah, they try.
And they did. I wasn't prepared.
All right.
But at least for their questions.
Yes.
And it felt like I was absolutely, I mean, I was a lot younger back then, but it felt like I was, put through a mincing machine, and both. Both the prosecutor and the defendant side. I was like, oh my God, thank God they're not using me, because I would have felt like my whole career was over.
That's right. They shoot you down.
Yeah, this is going to be publicised in the paper that psychologist is incompetent, and knows nothing, and somehow got through uni with no bloody idea. That's what it felt like.
But it is. I mean, and I think it is your obligation as a lawyer to warn your client. I don't know how you're going to perform until. I have seen clients who have totally fell apart in cross-examination. If you had started asking that client whether he was responsible for the last 10 unsolved murders in Canberra, he would have admitted that too. He just totally fell apart. And we didn't see it coming. I had a barrister. I didn't see it coming, and he was awful. He was a terrible witness. So, so that's the danger of going to court instead of the alternative of owning the outcome through a mediation.
Well, that's what I was basically doing. They'd ask me a question, and I hadn't learned at that point, because I was young, that I can say I don't know.
Yeah. Okay. Yeah.
So I had to come up with something for everything.
Yeah.
And the moment you come up with something that you don't know, you've just opened up 700 holes.
That's right. That's right.
They were just having a field day, right? And I was just fluffing about. That's what experience does. Now, in all my reports, and whenever I do any of my work, half the time the answer is I don't know, because the genuine answer is, how could I know? I'm not a mind reader.
True.
How can I go out and be a specialist of probabilities?
Your brief is only what it is.
Exactly. And so I think, as you say, things can go pear-shaped by going to court, and it's not it's not always known how someone will respond. And I know that psychologically. People go into an environment, they feel completely overwhelmed. Their fight or flight response kicks in, and some of us do exceptionally well, and some of us do abysmally and poorly. We go into the freeze mode.
Yeah.
And most people who have felt what freeze looks like is when someone asks you a question, and it could be, "What's your phone number?" and you cannot recall your phone number. You're completely incapable of recalling simple information, and you're being asked
because
something.
of the state you're in.
And of course, at that point, how are you going to go out and give any type of credible evidence or opinion or whatever it might be?
That's right.
No different to if someone's really, really shy in social situations, they're going to struggle to remember people's names. Because in that state, someone says, "Oh, nice to meet you. My name's Peter," and it's like all I've heard is.
That's right. That's right. Yeah. But look, and also, so it's important that people understand that it's rare. It is rare. It's not like in the movies. And my example of my client who was probably prepared to admit all the latest unsolved murders is an exception to the rule. It is very rare that you break a witness. It's at the end of the day, is how many punches you landed. You don't do knockouts. It's rare that you do knockouts, right? But still, the whole process of a trial is important that people who are going to go to mediation know is that you're going to throw as much dirt as you can to the other party and try to say as many things you can to discredit that other party, what you were describing before. And if it is a case, say, a couple who are raising children together or whatever, it's not great, which is what we were saying before about litigation tends to lead people growing apart. Mediation may help to break the barriers. So there are other important reasons to avoid litigation, not necessarily because it's going to break you. Yeah, well, it will be very expensive. You have no control out of the outcome. It could take a long time before you get an outcome, a million things. But it's also that damage that you're causing to that post-separation relationship in a family law matter and so on. It's important to avoid that if you can. Yes.
And that's that real importance of what can you live with, that if we get in the ring,
yes,
so we can have a conversation here, or we can get in the ring, which is called court.
Yes.
Put on, and in actual fact, take our gloves off.
Yeah.
Right? Because we're going to hit as hard as we can.
Exactly.
To discredit each other, to throw enough mud. That's what we're paying our lawyers to go out and do to get our optimal case. And at that point, we're not going for middle point, right? Because we're asking the judge to make that decision. So we're saying, I'm going to persuade as hard and as heavy to the absolute optimal, right? I want the whole lot,
Yeah.
Let the judge decide, but I'm going to throw all the reasons why, this person was abusive and they, kept money away from me and they've got 15 other accounts and they
all that. And it's all going to be in writing in affidavits, all these things that you said. Those things don't go away after that. So how do you do that? What do you do after that? Okay, now we have to talk about which school the child is going to go to the year after the litigation, or in 20 years you have to turn up to your child's wedding too. Maybe you have to make joint decisions about it. What happened at that trial so many years before doesn't go away. That's it.
Much more damage. So. Yeah, much more damage.
I think mediation is a very good way to try to resolve disputes, or at least one of the other methods, through alternative dispute resolution is worth it. Most people do it. Most people are smart enough to settle their disputes. Something like 95% settle their disputes. The problem is whether you do it at the beginning or closer to the... If you do it at the steps of the court, probably you already spent a lot of money.
Yes.
You probably wrote all the affidavits saying, do it early. Yes.
What would you say to someone who's currently in the process, or looking to start the process, or towards the end of the process? What would you hope for them to consider, to think about in mediation?
The courts will want you to try mediation or any form of negotiation. So it is becoming more and more so obligatory. Now the civil court is doing it too. The court just across the road from here, the Supreme Court, and the family court, of course, does it. That they force you to go to mediation. Don't just go through the motions. Take the opportunity to use it. Yeah. You are not allowed to commence court proceedings in a dispute about children unless you've been to counseling or mediation. You have to have a certificate to say that you tried. I mean, there are exceptions like domestic violence and so on, but don't just go through the motions. Use it. I tell clients that all the time. And the best part of a parenting plan is agreeing on the terms and conditions, and do it early. Do it early. You just split up. Try to do it now.
I like that idea as an ending point of really engage. Try and genuinely come to some sort of resolution, because 95% of you will anyway.
Exactly.
Let's not spend $20,000 each trying to get to the steps of the court.
Don't do it because of financial or physical fatigue. Do it because you want to hear.
Yes. Do it early, and in doing so, we don't damage the relationship that you're likely to have in many years to come in many instances. If it's going to end there anyway.
The hardcore 5%, keep the lawyers busy. Don't worry. The hardcore 5% do, because it doesn't matter what legislators do or what people try to do to change it. There will be 5% that will fight all the way and will not agree on what day it is today. But can I make another position as well in terms of probably my own experience? You're talking about when to use a lawyer. Obviously, there is always that 5% that will keep you guys busy. I found in my case, I utilised time with Mitch, as you know, yes.
And I also used him in a way where I was self-representing. Part of the time and part of the time here, and I found it incredibly valuable to go out and get consult.
Right.
So not necessarily representation the whole time, but rather going out and saying, "Hey, Mitch, what do you reckon? This is the situation. How should I approach it?" And he put together this amazing sort of folder for me in terms of if I. When I do go to court itself and along with who's the litigation
Matthew
Bridger, Matthew Bridger. Shout out to Matthew. Both Mitch and Matthew were absolutely brilliant in prepping me, and I felt like $1 million walking out from an hour meeting. Because I kind of felt like I knew a little bit. I didn't know it all by any means.
I think it's important that, I think what they gave you,
vital.
I remember that. I remember I met you in the corridor and you were telling me about it.
I was probably beaming at that point. Right, I was like, "Hey, Carlos, hey, yo."
That's right. But I think what they gave you was a framework. You do need that framework. And
preparation.
Is a preparation, but you can use it whether it is to go to a tribunal or litigation, or to go to mediation yourself, because the mediation may or may not include lawyers, but you need to have the framework. So you know what is likely to happen if the matter goes to court, your rights, your obligations and so on, your limits, and then you decide what you want to do. It could be not a legal outcome within that range. It could be, that's what I said about, it could be something totally left field. But one of the things I say to clients, even clients who want to settle something that is not a good outcome, I don't think is the better outcome for them, is at the very least you have to know what you're losing, right? At the very least, you have to know, if you choose to do that, I cannot make a decision for you. But you have to know that if you went further, you will get another outcome.
And I'll tell you what, that raises a point about what are you willing to live with, because the currency is extremely important. So I spend a lot of time, obviously, in a confidential room with my clients, and I hear, people's currency. Someone saying, I don't care about,
that's right.
This big matter. Everyone's telling me, no, don't. You're entitled to more, or And it's like, I don't care about these entitlements because I'm not interested in that. That is not my currency. And that's so important to try and appreciate and understand. And so
as long as it's not loaded, I guess it's not. I don't care about you keeping the house because I was unfaithful to you. Right?
That's different. Yes.
Right. So you have to. I mean, I work. I'm a family lawyer, so you get a lot of that. People coming in who is a different form of grieving or whatever it is, right? Or different things that are going on in people's heads. When they first split up, but then they move on from that. The guilt goes away, the grieving goes away, and they feel different. So as long as they are not saying, I don't care about that, when in reality is, I don't care about that because I feel really bad about what I did to you, right? You agree with that? Yeah.
Well, it's almost about, the big sort of air quotation, marks for informed consent.
Yeah.
Yeah. We want someone to be able to agree to something fully informed.
Yeah.
And
that's exactly right. I always say that to clients. Look, if you know what you're doing and why you're doing it, and it's not because it's loaded with some emotional stuff. Okay, sure. Now, if you're
that's the reason to engage a lawyer, right?
Yeah,
so that you can make decisions fully informed, not sort of biased towards, this is what you're entitled to, but rather informed about the process, about what it might look like and what we're trying to achieve and so on. You're in a much better position to go and say, I can live with X, even though I'd like Y.
Yeah. Exactly. Yeah, that's right. And sometimes when people have that position that they somehow the judgment is loaded from one of those considerations, and I may or may not know about that, but and probably you are a better person to assess that than I am, but sometimes they say it or they tell you why they split up, so you may know. And I often say to them, if you're going to make a bad decision, what's the hurry? Why don't you wait for 3-6 months, right? And sometimes it resonates.
That's actually brilliant. Take your time and do it well. Yeah. Carlos, we could speak for hours.
We could, and we haven't even got pizzas.
I know, no pizzas this time. How can people get in contact with you? Obviously, we shared it last time on our podcast, but for those listeners today.
It's Elrington's Lawyers. The phone number is 6206-1300. It is elringtons.com.au. We have a website with a lot of information. There are a lot of articles about many subjects, and I always invite people to go through those articles. It's a good way to introduce yourself into topics. They're not totally comprehensive about any particular theme, but they introduce you to themes. So I find that, I think the feedback I get is that it's quite informative.
Fantastic. Carlos, thank you very much for coming on again, and I hope we find another time for you to
thank you.
Slot in.
Thank you for the invitation, and thank you for the coffee, Nesh.
My pleasure.
Thanks.